Landmark case: DRC takes Rwanda to African court over human rights violations. The ongoing conflict in Eastern Democratic Republic of Congo, DRC, has sparked growing calls for non-military solutions. One of the most significant efforts is a legal case brought by the DRC against Rwanda before the African Court on Human and People's Rights, the judicial arm of the African Union, AU, responsible for protecting human rights across the continent. This case, filed on August 21, 2023, is the first ever interstate dispute submitted to the African Court. The DRC accuses Rwanda of violating the African Charter on Human and People's Rights by supporting the M23 rebel group. According to the DRC, M23 has been responsible for mass killings, widespread displacement of civilians, destruction of schools and infrastructure, looting. Rwanda, however, denies any involvement with M23. This case is not only about the DRC and Rwanda. It could set a major legal precedent for how African nations resolve conflicts and hold each other accountable for human rights violations. If the court rules in favor of the DRC, it could encourage more peaceful dispute resolution across the continent. Before the case moves forward, the African court must decide whether it has the authority to hear it. At a public hearing in February 2025, Rwanda argued that the case should be dismissed for several reasons. No territorial jurisdiction. Rwanda claims the alleged human rights violations took place outside its borders, meaning the court has no authority over the matter. No clear dispute. Rwanda insists there is no formal legal dispute between the two nations. Failure to exhaust legal remedies. Rwanda argues that victims should have sought justice through Rwandan courts before bringing the case to an international level. Abuse of process. Rwanda also objects because the DRC has filed a similar case before the East African Court of Justice. The DRC strongly disagrees, arguing that countries are responsible for human rights violations even outside their borders if they have control over the situation. A dispute exists, as previous diplomatic efforts to resolve the issue have failed. Expecting thousands of victims to seek legal remedies in Rwanda is unrealistic given the ongoing conflict. The case follows the African Charter's rules as it has not been settled by another court. The African Court deliberated on the case after the February 2025 hearing. A final ruling is expected in early June 2025, as the court must issue its judgment within 90 days of deliberation. This case is a major test for the African Court and the AU itself. Even if the court rules against Rwanda, enforcing the judgment will be challenging. The court does not have an enforcement arm. However, the AU has the power to pressure non-compliant states, including by imposing sanctions AU's Constitutive Act. So far, AU member states have been reluctant to use this measure. This case is a historic moment for African justice. If successful, it could strengthen the African Court as a legitimate avenue for resolving disputes, encourage African nations to settle conflicts through law rather than violence, hold states accountable for human rights violations, setting a legal precedent for future cases. For now, all eyes are on the African Court and its upcoming decision. Whatever the outcome, this case will shape the future of justice, accountability, and peace building in Africa.